Welcome to Summer Associate Hub's live Intro to Litigation Practice Showcase, everyone. If you're joining us tonight, you may already know that you are 100% interested in practicing litigation. You may fall into the category of still trying to figure out what practice is right for you. Maybe you were with us last night, or maybe you find yourself somewhere in that in between, curious about what types of litigation there are. My name is Paula from Summer Associate Hub, and I'm proud to have you all here. No matter where you land, you are in the right place tonight. Our session features some really great firms that I'm sure you've heard of, and we're going to hear from the attorneys that are practicing litigation day in and day out, and hopefully we'll be able to answer the questions that you have. Before we jump in, a little bit about Summer Associate Hub. Summer Associate Hub is a free content and resource hub for law students embarking on their 1L and 2L recruiting process. I'm a proud former big law legal recruiting professional, so I know firsthand how wild your first year and second year experience can be, especially when figuring out what it's really like to work at a law firm. Our platform, Summer Associate Hub, has blog posts, podcast episodes, short video tutorials, and exercises, interviews with attorneys, and other content to help you learn more about the litigation practice and figure out where to go from here for your recruiting process. A little bit about recruiting process. Our registration is currently open for our upcoming job fairs happening on Friday, January 30th. The date for application submissions for those fairs is January 20th, and the portal opened today. So if you're interested, please check out the chat here. You'll be seeing a couple of links for a few different things come through. So keep your eye on that for the registration link, and then keep an eye on your inbox for more information. And as always, the best way to stay updated is to sign up for our newsletter, which if you signed up for this event, you're in luck because that means we've automatically added you to our newsletter. It's a lot of information, but what does tonight look like? We will hear from our attorneys, our panelists for brief introductions, and then after introductions, jump into a panel discussion including what our panelists day-to-day looks like, how law students can figure out the differences between the different types of litigation, and then what about each firm makes it stand out specific to their litigation practices. If you have questions specific to tonight's presentation, please do drop them in the Q&A. I'll be keeping an eye on it in case we do have time for a few live questions. We'll be doing breakout rooms after the panel. I highly encourage you to stick around so you have time to ask questions live, engage with these firms, network, hear what your fellow law student colleagues have to ask as well. FYI, public service announcement, to join the breakout rooms, and I'll remind you of this again, you do have to be using the desktop Zoom app on your computer. If you're joining via mobile or a browser, you might not have that breakout room function. So just a heads up in case you need to switch over in order to join those breakout rooms. There will also be fun prizes. We like to do that here at Summer Associate Hub. We'll do that later in the presentation. Again, something in order to join, the link will be registration link for that fun thing will be in the chat as well. The trick is you do have to be here live when your name is called live, and then you'll find me, I'll find you. It'll be great. At the end of the panel, right around 8:15 Eastern, I'm here on the East Coast in New York. Each firm will host a separate breakout room, like I said. As a reminder, you need to be on the desktop app. And on that note, everyone looks like people are still trickling in, and that's great. The more the merrier. And on that note, it looks like everything is working and we're ready to get started. So we are going to do introductions. Please, to my panelists, Jack, and Tommy, please introduce yourself and your practice at your firm and briefly why you chose to work in this practice area. And we'll go on just what my screen looks like. So Tommy, you're first.
Sure. Hi, everyone. My name is Tommy Du. I'm a partner at Robbins Kaplan in our Los Angeles office. I practice commercial litigation with a specialty in commercial real property. It's a practice where I'm focused on representing businesses and their disputes, whether it's a commercial lease with a well-known rapper where he ends up destroying the property, or as it relates to the purchase of a machine to help wrap donuts for production. That's kind of what I do, is handling a lot of contract disputes. What I enjoy most about commercial litigation is being able to use my background and experience and to break down some of these complex, oftentimes mundane issues for the jury and for the judge, and to keep them interested and to be able to tell that story from beginning to end.
Excellent. Thank you. and we're gonna come up against this all night. So Jack, you'll go next, but how about we do Jack Robinson? You'll go next.
Perfect. Hi, everyone. I'm Jack Robinson. I'm a litigation associate in the New York office of Troutman Pepper Locke. My practice focuses mainly on commercial and business litigation, which means I'm helping businesses resolve disputes that grow out of everyday business relationships. So business to investor, business to customer, all of it. I chose litigation pretty late in my law school career. I didn't go the normal summer associate route. I actually decided after law school, following a clerkship that I had with a judge, that I decided litigation was the route for me. But I liked the idea of, taking messy real world problems and learning messy facts from messy people and applying the law in a clear, persuasive way to a judge. And I kind of like doing that from start to finish. One of the cool things about litigation is you can finish a litigation in a week or 10 years. And so I kind of like seeing that whole process play through.
Awesome. Thank you. Jack Millman, you're up.
Hi all, my name's Jack Millman. I'm a partner at Holwell Shuster's New York office. And like my panelists, I also do commercial litigation. One of the good things about Holwell is, and why I'm there, is they sort of do a wide variety. So it's very much a general complex commercial litigation practice. And so what that means is we'll have breach of contract disputes, we'll have trade secret cases, there might be real estate. We have cases, in the DC circuit involving administrative action. And it's also a nice mix of trial and appellate work. And like the other Jack, I actually came to litigation a little later. I thought I'd be a tax attorney at first. I actually worked as an exec comp associate for a year. And what ended up happening is sort of through law school and the clerkship, I just came to realize I really enjoyed the law and litigation and kind of the intersection of the facts and law and shaping these arguments, shaping the cases, both at the trial and the appellate level. And so that's why I ended up here.
Awesome. Thank you, Jack, and thank you, everyone. And Jack, if you don't mind, if we could stay with you for a minute and kick it off, what are typical matters you'd work with? What does your day-to-day look like at Holwell, including elaborating a little bit more on the commercial litigation side versus the appellate litigation side?
So one of the things I think I like about litigation as well is there is such a variety. I think it was Tommy talking about like the donut machine. You'll get these cases and you'll dive in on this area of business you never knew existed. So you might, go in and realize, oh, I never learned about this, item, but then it turns out to be very interesting and exciting. Like I have a case involving high-speed trains that was very fun to work with. In terms of day-to-day, for cases that are at trial or in discovery, which is after the complaint has filed, but before the case has gone to trial, it'll sort of depend very much on what phase of the case it is in. So you may be helping a client prepare to file a case or analyze litigation options. You may be working on drafting a complaint, figuring out where to file, kind of the initial litigation strategy. The main case I'm working on right now is in the midst of fact discovery. So it's a lot of analyzing documents, letters back and forth, motion to compel practice, kind of fighting over shaping the facts that will eventually, if the case continues, get us to summary judgment and trial. So, I had another case that ended recently that we had gone through depositions. And so that was a lot of, deposition prep, preparing to take witnesses, taking the witnesses or defending, and then getting ready for our expert reports and summary judgment. And so the day-to-day on the trial side very much is what trial team and where the state of the case is, but it's usually something along, those lines. And then in terms of appellate work, we have a mix of state and federal appellate cases. So I had a brief in the Ninth Circuit that went in a couple months ago. There's a case in the Second Circuit. There's a case we're working on the DC Circuit. And for appellate briefing, it's very much generally scheduled in advance. So you sort of know when the brief is due, when the other side's brief is coming in. And depending on where you're at in the team, you'll be doing some mix of research and writing. So, if you're a more junior associate, you may be the one researching and drafting a section, giving it to the partner. They might turn it, have further questions, and so on. And that small team would be working together to draft the brief, and then eventually, once all the briefing is done, prepare for argument.
Awesome. Thank you so much. Tommy, what does your day look like?
Yeah, I think Jack summarized it pretty well, and I was going to break it down similarly, which is, what your day-to-day looks like on a daily basis, and kind of what your day-to-day looks like when you're actually in litigation in court trying cases. I would say that your day-to-day, most of the time, 90% of the time as a litigator, is much less about courtroom dramas like, suits or linking lawyer. And it's more about writing, analysis, and strategy. I would say that on a typical day, I might be drafting, editing motions, briefs, discovery, and really early on in a case, it's more about investigating and trying to frame the story and how best to tell your client's side of the story, but also identifying any pitfalls or any disadvantages or weaknesses in your cases and kind of flushing that through discovery and finding the right procedural vehicle to kind of do that. But as the case progresses, it's more about distilling all the facts that you have and trying to find ways to make it more persuasive to convince a judge, arbitrator, or jury that why your version of the facts makes sense and why you should win. And so I would say day to day, it's more about drafting, writing, and researching. And then when you're in litigation, it's really when it's all hands on deck. And litigation, when you're actually in trial, is what I love most, where you're essentially living, sleeping, breathing the case. And you're pretty much focused on a case 24/7 for however long trial is. Trials can last anywhere from a day to a month to 6 months. And during that time frame, you're really doing everything it takes to get ready for the next day. I would say that in a month leading up to trial, you're essentially getting your stuff ready so that it essentially becomes a production when you're at trial. Especially when you're presenting in front of a jury, you really want to be able to do everything that is already pre-planned. And then during trial, as you're going through, presenting your witnesses or presenting your statements, you're refining that throughout. And so I would say that, pre-trial, getting ready for trial, it's more about investigating. And during trial, you're kind of living the case where you're essentially working almost, I would say, 12 to 14-hour days at a minimum to present your case to the jury in a way that makes sense and it is essentially like trying to put on a play as to what your witnesses will say and how you plan to cross-examine the other side. But unlike a play, I would say that things will come up every day that changes your perspective, which will require you to spend a little bit more time to figure out how to deal with it the next day. But that's my quick version of what a litigator does on a daily basis.
Great. Thank you. Jack, what are your days looking like?
Yeah, so I'll try my best not to repeat what's already been said, but I do agree with Tommy and Jack on everything they've mentioned so far. For me, in my practice, I have the benefit of being somewhat of a generalist as a litigation associate, in that, the substantive law might change from day to day or hour to hour, depending on different partners I'm working with on different cases. So, anything from consumer finance to class actions to construction litigation. It changes by the day, but one of the things that doesn't change is, all the work tends to really fall in a few buckets. So it's fact development, discovery, talking to clients, coming up with strategy, legal research and writing, which is always a big part of my day. And I think one thing to keep in mind is that oftentimes for litigation, a lot of it is not even in litigation yet. You're trying to keep your client out of litigation. You're trying to stay out of court and reach, a resolution with an opposing party. And so, kind of like what Tommy was saying, a lot of litigation is actually spent outside of court, depending on your strategy. So that's my day to day.
Great. And I'd like to stay with you, Jack, for this
Yeah.
one. Let's talk a little bit about how, and everyone can chime in, how students can differentiate the different types of litigation. So the work it falls into the three different types of buckets, like you said, but what are the different types of litigations? Can you all talk a little bit about your specialities and how you wound up there?
Yeah. So, obviously there's different substantive, practices and industries within litigation. A lot of what I do in commercial litigation is, consumer finance litigation for banks and mortgage companies, business disputes, contract disputes, financial issues. Um, but oftentimes with those same clients, they're going to be involved in investigations. And so that's a different side of being a litigation associate, where you might be assisting the government or some quasi-government authority with an investigation and preparing a strategy for that same client in that regard. Um, a lot of what I do is class action work, and that takes years and years and years. Um, and so, it falls into a lot of different buckets, as we keep saying. Um, One of the things that differentiates, types of litigation too is the pace and the style. One thing that I like about class action litigation, for example, is that it takes a long time. Some people love, fast-paced cases where, you're applying for temporary restraining orders and injunctions, in a matter of days, and you're before a court in a week. Um, I tend to lean the opposite way. Um, and I enjoy cases that play out for the long term. Um, and then, yeah, kind of just like what I was saying before, litigation often kind of depends on who the main players are. Sometimes it's all court focused and you're going to appear before a judge. Sometimes, for example, employment litigation, you might be dealing with administrative departments and dealing with, quasi-government officials that way, which is oftentimes a little faster paced too. So that was a very long-winded answer, but there you go.
It was great. Excellent. Um, our audience are law students tonight. So what steps can a student take to go to a level deeper in learning about litigation? They're here tonight, great step. But generally, what can they do as a student, future summer associate, to take that step?
Yeah, I'm happy to jump in on this one. I'd say that there's really two things that students can do, and it's something that I did throughout law school and even undergrad, which was doing mock trial. I know that in law school, there's a huge emphasis placed on, moot court or appellate litigation. But if you truly want to understand what litigation is like, at least what it's like to go to trial, I would say doing mock trial is a really good way to get exposure to that. And I know a lot of law schools have internal competitions, and I think there are also external competitions that students can do to get a basic understanding of what mock trial or what trials will look like. The other thing law students can do is actually just go to a courtroom and just watch a hearing or watch a trial. Hearings are 99% public. And so if you want to just watch a hearing, you get a sense of what the pretrial disputes look like, and just, seeing how lawyers argue. And I will say that most of the times when you see a lawyer in a courtroom, they're not that great, but it's a way to learn and see how you can craft better persuasive arguments. Or, if you have a little bit of time on your hands, go actually watch a trial, see how examinations are done. And I would highly recommend just watching the closing argument or the opening statement and watching one or two witnesses just to get a flavor of what all the pretrial work kind of leads into when you're at trial.
Yeah, I think what everything Tommy said is good advice. And then I'll also say, to the extent you have a particular type of practice area that you might be interested in, like commercial real estate, white collar defense, which can have very different paces and styles and types of work. Trying to, as best you can, maybe reach out to people you know, acquaintances, talk to professors who might know people who you could get in touch with, and just have, a 30-minute coffee or a phone call and talk about, okay, you're in a white collar practice, you're in a deal litigation practice. Can you sort of talk about what that means? Do your cases settle? You're interacting with the government. How does fact discovery work? Because you'll find, as Jack said, they're very different. There's types of cases, if you're focused on complex antitrust cases that are going to take many years and that will very rarely go to trial. And then there might be types of cases that are faster paced, that are TROs and PIs, and you might be in court more. And so often the best way to get a better sense of that is to try to find someone who has a kind of particular specialty and reach out to them.
Yeah,
Yeah,
I think
and
that's a very good
oh,
point.
go ahead.
Sorry, go ahead, Jack.
No, I was just gonna say, one thing that I thought was beneficial in law school was like a trial advocacy clinic, if that's something your law school offers. I appreciated it because it kind of demystified the whole courtroom experience for me, which I'll, fully admit I was a little fearful of until then. And, even if it wasn't substantively what I wanted to be doing out of law school, and, it was, I think it was some family law and housing tenant law and areas of law that I didn't necessarily see myself practicing. The routine of going in front of a judge and practicing your argument, um, again, just kind of demystifies the whole thing, and you can kind of give you a better idea of if you see yourself doing that after law school.
I agree 100%. I just wanted to add to what Jack was saying. In law school, I was really interested in antitrust. I love doing antitrust, and learning about it. But when I actually talk to people who practice antitrust, I learned that, it doesn't often go to trial. And for someone like me who loves actually being in trial and presenting a case, I realized that was not the right move for me. And so along the lines of what Jack was saying, which is talk to people who are actually practicing that practice area to get a sense of what the day-to-day looks like. And I think there's no one who can give you better advice than someone who is actually practicing in that particular area.
100%. On that note, what is the most interesting case or question you've worked on, each of you? It's a big question. It could be recent. It could be most interesting case, to the extent you can share.
So I'm happy to start. This is I mean, it is very interesting, which I guess is why it's my answer. So I had a pro bono case I took when I was at Jones Day. And a lot of firms will have sort of opportunities for this. It was a pro bono appeal of a guilty plea that had an issue, and the government actually conceded error. And when it came back down, we got to this unusual place where my client got a reduced sentence, which was a very big victory. But it appeared that there may be a couple of months left on his sentence, but he might have sentencing credits and thus not have to serve any time in prison. However, the government and the prison said he had to report to prison to figure out how many credits he had. And so we were in this, Kafka-esque scenario where they said, well, go to prison, sit there for a month, and then you'll find out you have no prison time. And I was like, well, that's unacceptable. Just tell me how many credits he, has. And they said, well, we can't tell you that till he gets to prison. And, we were looking into this, and there's other associates helping. And it reminds me, we eventually managed to convince the judge to essentially amend the sentence to eliminate the issue. But along the way, and this will happen in so many cases, you'll realize there's no answer to a question, or no good answer, no controlling law when you think, oh, this must have come up before. There must be a bunch of cases about this scenario. And in fact, many times you'll come to understand the law runs out a lot quicker than you think. And that's part of maybe the fun of litigation is, when the law runs out, which it often does, it'll be up to you to sort of put the facts together and analogize and make that case to the decision maker. And it won't be as easy, and often is not as easy as just saying, oh, here's, three cases that exactly control. Much more often, particularly, discovery and the trial court litigation, it is very much, here are some examples, here is some policy, here are some facts, and you're kind of weaving it together on the fly. So that case is just, I think, a good illustration to me, because I was so surprised that by the lack of answer, and then we, put together the best argument we could, and you know, we extended the law in what I thought was a favorable way and got a good result for the client. So
That's awesome. Thank you, Jack. How about we'll go on to our other Jack, your most interesting case.
Yeah, so I was thinking back, this litigation doesn't happen as much anymore. But back in the day, everyone will remember the PPP loans that happened after COVID, or during and after COVID. And our firm represented lenders and servicers of those loans a lot of the time. And everyone will also remember that there was a lot of fraud that went along with those loans and loan applications. And so what would happen often is borrowers or hopeful borrowers who did not get a loan would sue the lender or sue the servicer looking to receive their PPP loans. And I would have these fun moments where I got to play detective a little bit, which doesn't happen as often as I would like because it's always a fun moment. But, you're looking at a bank statement that's been given to you as part of a PPP loan application, and you're looking at bank statements from the same bank that you subpoenaed, and you're finding out that, bank statements have been doctored. And so you're kind of discovering, fraud for the first time, which is pretty neat. But yeah, that was what first came to mind, some interesting cases there.
Very interesting. Thank you. Tell me.
Yeah, so this is a case that it's also a pro bono case. We handled it a few years ago and it recently came back to us after appeal. So we represented a class of homeless veterans in West Los Angeles seeking housing. Um, in West Los Angeles, there was over 600 acres of land that was donated for disabled veterans back in 1888 to the government to use to house homeless veterans. And for a good 30 years, the VA actually used that land to house homeless veterans. And at its peak, there were probably about 3,000 homeless veterans that were housed on that property. In the 1900s, over time, that property was slowly given away to special interest, and just a variety of different things that have nothing to do with housing homeless disabled veterans. And so, you flash forward almost 150 years, and that 600 acres of land became 388 acres of land. And we have a ton of homeless veterans in West Los Angeles, and this land housed no homeless veterans. And so our firm brought a class action lawsuit on behalf of these veterans um, to essentially build housing on the West Los Angeles VA property. We tried this case back in August of 2024. It was a month-long trial, a pro bono trial in front of Judge Carter. We won everything we asked for at the trial court. What was fun about that case was, we got to try the case for about a month, but in the middle of the case, in the middle of the trial, Judge Carter ordered us to go to the West LA VA property to do a site inspection, where the government said, we brought you golf carts to take a tour of the property. And Judge Carter, being who he is, you can look up Judge Carter later, but he said, I want to walk the property, which is 10 miles long. I want to walk the property as a veteran would, who would live on this property and see it for myself. And so we start the tour of the property at 5 a.m. We didn't finish until about 10, 11 a.m. And he says, okay, you guys can all go take a break, be back in my courtroom at 1 p.m., and we're going to keep going with trial. And we did the trial that day, and then he ordered us back to the property at 8 p.m. And so it was one of those, that's kind of emblematic of what really a trial day looks like, is you can start as early as 5 a.m. And we didn't finish the site inspection that night until 11 p.m. And then we restarted the case the next morning at 8 a.m. Judges ultimately hold all the power. But in this particular case, we worked on a case that had a good outcome. The government ultimately appealed to the Ninth Circuit, and we got the appellate decision December 23rd of last month, mostly in our favor. And so we're just waiting for it to come back. And, what our goal was and still is to get housing built for homeless veterans in West Los Angeles. And the Ninth Circuit has affirmed that portion of the decision. And so we're just waiting for the case to go back and hopefully crossing my fingers that we can start building housing for homeless veterans and, making a difference in our community.
We'll definitely be following that case, and I hope everyone on here follows. That's awesome. It's been great to hear about your specific practices. And now, before we go into our breakout rooms in a few minutes, I want to end the panel with this question of each of you, from each of you, in 30 seconds or less. Why should someone choose your firm? Now, we have a rule at Summer Associate Hub is that you cannot answer this with the people. We know everyone loves the people at their firm, and that's a big answer, but we try to ask you not to say the people are only the people. So how about, Tommy, we'll go back to you. Why Robbins Kaplan?
Yeah, I love the people in my firm, but Robbins Kaplan is a litigation-focused firm. We give all of our associates hands-on training tied to real cases, and junior attorneys actually get a lot of experience in trying cases. We associates will do research in the background, but they also draft briefs, take deposition, argue motions, and get meaningful trial exposure. And we actually send our associates to training in different areas of the country so they get to experience that. And because we actually try cases, I think associates and attorneys actually learn what litigation looks like. And if you like, being able to tell a story to a jury, Robbins Kaplan is a place for you.
Excellent. Jack Millman.
Tommy's answer is very good. So, similar, the people are fantastic, of course. I would also say, I've been at a couple different firms. I'd worked before law school. One thing I really like about Holwell Shuster's, it's a single office. We have maybe approximately 60 partners and associates. The teams are small. You feel like you get to know everybody. Junior associates, people are contributing to strategy right away. They're seeing how the case unfolds right away. They're, working on the depositions. They're working on the summary judgment. They're sort of being able to work at all levels. And when I was thinking of, where's a place I want to practice law with excellent people who are all kind of in it together, contributing at this highest level, and you expect the people that you're hiring to be able to be partner, to be able to step up, to be able to speak in court. We had the two, I think, largest victories at this firm with Zunum and Walmart. We had associates, take witnesses, stand up in court. And so that type of expectation and the fact it's normalized and people all get along and you sort of know what everyone is working on, those are all just very attractive qualities and, why I'm here.
Awesome. Thank you. Jack Robinson.
Yeah, so echoing a little bit, I would say that, especially important for summer associates and entry-level associates, Troutman Pepper Locke has a real meaningful responsibility for associates early on with real support behind all of them. As a junior litigator, you're not just in the background, you're doing the work alongside senior lawyers, whether they're associates or partners, and kind of going along with that. One of the things I appreciate the most is the mentorship. We have formal and informal forms of mentorship, formal as a summer associate and an entry-level associate, but then also you build those mentorships as you go. And you'll have, senior lawyers who teach you and explain things to you and, discuss strategy with you along the way. So I would say mentorship for me.
What a great note to end on. Thank you very much to our panelists for joining us tonight. It has been great to learn from each of you. And thank you to our audience also for making the time to be here tonight. We know how precious everyone's time is, and we appreciate you spending it with Summer Associate Hub tonight. Don't go anywhere yet. I am going to hit the stop record button so we can go into our breakout room.